I don't think
We're
that's.
on.
After a while. And then
We're on.
Township of Parsippany-Troy Hills, regular Township Council meeting of April 21st, 2015.
Adequate notice of the meeting has been provided in accordance with the requirements of the Open Public Meetings Law by filing the notice in the office of the Township Clerk and by posting the meeting notice on the bulletin board at the municipal building on January 8, 2015, where it has remained posted since that date. A legal notice appeared in the Daily Record on January 12, 2015, and the Star Ledger on January 14, 2015, and was forwarded by fax to our local newspapers and local radio station on January 8, 2015. Note, council meetings are videotaped and aired on Cablevision Public Access Channel 21 at 11 o'clock a.m. on Sundays and are also available for viewing at www.parsippany.net.
Please rise for the flag salute.
Glory, if you would. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Mr. DePiero.
Here.
Mr. Paluso.
Present.
Mr. Stanton.
Here.
Mr. Valori.
here.
Council President Karifi.
Here. Also present, Mayor James R. Barberio, L&M Sandman, Business Administrator, Paula Cazzarelli,
she's
Oh,
out.
Paula's not here.
She's out ill.
John Inglesino, Esquire, Township Attorney, Yancey Resermis, Township Clerk, Ann M. Cucci, CFO. Upcoming meetings, May 12th, 2015 at 7:30 p.m., agenda meeting. May 19th, 2015 at 7:30 p.m., regular meeting. Budget meetings,
I'd like to make a motion that we cancel the meeting for 4/23/2015 due to the fact that we just received the budget today.
Councilman Stan, do you have another date recommending?
We would have to sit down and decide what's good. I don't have anything at this time. I didn't expect to receive the books at this late into the...
All of the items that are scheduled for 423 are not complicated, not controversial type items. It shouldn't take too long to review those items and not push this back.
And just to make note, for the record, myself and Paul Karifi did meet with the Finance Committee, which the mayor was present today, the CFO and the BA, and they, gave us a cursory inspection of what was going to be taking place for it. So I'm confident, based on the information we have,
Okay.
we would do.
I'm just saying it on my own behalf, just because of what I have coming for the next 2 days. I will not be prepared for Thursday whatsoever.
No, that's understandable, and we're just going to be, going over everything, and then obviously we'll go back to the Finance Committee. If that makes you feel better.
That's fine. Okay.
Okay, budget meetings, April 23rd, 2015 at 6 p.m., May 5th, 2015 at 6 p.m., May 14th, 2015 at 6 p.m. Presentations? Mayor?
You're cured.
Well, short here, but I want to take the opportunity to thank the Council for Parsippany-Troy Hills Outstanding Achievement Award for Parsippany High School 2014 Track and Field Team, winners of the 2014 Northwest Jersey Athletic Conference, NJAC. So I want to congratulate you that are here today. So I'm going to call up certificates. I'm going to start with the head coach, Walter Bueller. Head coach Russell Smith. I used to run 100 meters in 5 minutes. Assistant coach Jeremy Chardrew, is it? Yeah. Okay, thank you. Jerry McMickle. Assistant coach Deanna DiGeronimo. Okay, now we have Catherine Campbell, who was the 2014 NJAC Small School Javelin Champion.
Oh, wow.
Allison Slosser. Running the 3,200 meter run champion. Brianna Saunders is not with us tonight, right? Yeah, she's a 100 meter dash and 200 meter dash.
Wow.
Great.
Jen Milmore? Yeah, she's a student. Okay, just tell me what.
Oh, yeah.
Gabrielle Ratchamou.
Close.
Megan Wisniewski. Eventually, on that side. Solana Ladonna. Samantha Pignatelli. Kelly Higginbotham? Okay. That's cross country. Julia Crevice? Catherine Hannigan?
I think some of them are here.
Well, they keep coming in, that's why.
It's the best age for kids when they're teenagers.
Gabrielle Rosnowski?
Highly deserved.
Michelle Herrera? Nicole Herrera? Emily Fails.
Yeah.
Liliana Ferrara? She's in class. Okay. Elena Figueroa? Tama Herbst? Amanda Angulo? And the last one. Katie Schuh? Thank you very much. Congratulations again, but we're going to do a photo op, so you'll come around this way. Council, would you like to come?
Yeah, it'd be great.
Wants to stand.
Right, you want us to just stand?
Want to stand?
And if you stand behind, that'd be good.
How about you? Just out of the way.
Congratulations, girls.
Yes, great job. Good for you.
I'm not gonna sit there.
I know.
Paparazzi.
Congratulations.
Great job, Ed. That's moving. Congratulations, ladies.
Yeah, no, she's distant. Brianne is the sprinter. She's in college. She was wasn't ashamed. Yeah. But she's real good too. Distant.
Got some good athletes up there.
Yeah.
They're big, I know.
God bless.
Orange has better.
I'm tasting, they had some gladiators back then.
Okay, next we'll have a presentation on the master plan.
What's the track team was?
If I don't know, if I could, I just wanted to welcome Ed. Ed has been a planner for a long time here in Parsippany, and he does a great job. And I thought Councilman Paluso had said, you know, it'd be a really great opportunity for not only the council and the administration, but the folks to see what's happening and what you're planning for there, Ed. So,
Thank you, Alan.
take it away. Yep. Yep, I'm sure. Give it a moment. There you go. All right, turn it on.
Good evening, everybody. Thank you for having me. Again, Ed Snikus with the firm of Burgess Associates. We represent the Parsippany Planning Board. And last year in December of 2014, we prepared and adopted, it was a year-long process, where the Planning Board reviewed the master plan. And it's something called the re-examination of the master plan. That's the statutory requirement that it falls under. Municipal land use law requires municipalities to review that every 10 years. The last one was actually in 2004. And so we were due for one, and we addressed several issues, which I'll give as a overview tonight in the presentation. There are a number of issues, though, in detail and things of that nature that may not be covered in this presentation, obviously due to the length of the report. But yet, what we tried to do is to give a general overview of some of the findings, some of the directions, some of the issues and problems that we were looking to address during the master plan review. There we go. According to the statutory requirements of the municipal land use law, there are several issues that need to be looked at in the review of the master plan. First is the major problems at the time of the last report. Secondly is the major land use issues currently facing the municipality. So you can see it requires that sort of update to the master plan. Third is the specific changes recommended for the master plan or development regulations, including objectives and policies and standards that may be related to that overall review. In addition to that, we also chose to update and review the land use plan. What the land use plan component of the master plan is, it's a required element of the master plan, but that it also provides for the underlying basis for your zoning. It provides the municipality with regard to the overall roadmap per se for the actual zone plan. And in that we had the land use plan analysis, and then there were some updates to the land use plan. The re-examination, as I mentioned, is every 5 years. We are recommending that it occur at 10 years. We're recommending that it occur at a 5-year interval. The purpose for that is that we feel that the needs change so quickly, especially with the community of Parsippany, the range of uses that you have within the township, the types of residential housing that we have. It's important to stay on top of that. So it's something that the planning board chose to include within the master plan is that recommendation. In addition to that, interestingly enough, the last comprehensive update of the master plan was in 1976. And so since that time, we've been doing a series of re-examination reports. It's really time to do a new comprehensive master plan at the next time. And that might be at that 5-year interval. And it's something that should be budgeted for as we work towards that. The next review is what we're going to recommend is the comprehensive master plan.
Some of the other issues that we reviewed, and again, some of these I'll go through rather quickly. This is the full presentation that we gave to the public. It's a required presentation you give for the public hearing. But yet, you can see what we looked at here. In the prior development and revitalization issues that were identified in the 2004 report were the issues relating to the SED zones. We were trying to address the issue of what's called adaptive reuse. With the change of the marketplace, the SED zones are your special economic development zones, almost light industrial type of uses that are in those zones. What we were doing in the 2004 report and then subsequently in the 2014 report is to recommend that those uses be reaffirmed but adaptively reused within those facilities, to try to encourage their reuse. If there's particular uses that we're not planning for or not permitted at the current time frame, try to be proactive and progressive in considering the reuse of the facilities so that they still remain viable and are productive within the community. In addition to that, we also looked at the LIW2 zone. We looked at the B zones, made certain recommendations for the B zones. Also existing tree resource preservation. That was also in the 2004 report, yet we reaffirmed that as well. Apologize, wrong button. Also, of the topics that we were discussing, that was the development and revitalization issues from the past report. We also talked about the prior transportation and circulation issues. We discussed the issue of the interchange of Route 10 and Route 53, where that interchange was proposed and improved upon. But also some other prior land use and policy issues were water conservation. We reaffirmed the need to be proactive with water conservation. And water conservation not only from, let's say, the actual building construction, but also in the landscape material. We're encouraging drip irrigation, things of that nature, native plant material, things that don't require additional watering so we can reduce our peak demands for water usage. In addition to that, we also reaffirmed the wellhead protection areas because Parsippany does rely on the sole source aquifer. It's very important to maintain our wellhead protection ordinance and to safeguard our wellheads throughout the township. In addition to that, we took a look at floodplain restoration and made additional recommendations relative to the floodplains. What's also provided in the report is a series of snapshots in time. It's required by the statute that we take a look at the growth issues of changing demographics within the community and what are the hot button issues at the time of the report. One of the main issues, as probably everyone is well aware, is the vacancy rate of the Parsippany office market. This is a snapshot in 2013 that shows in blue on the right-hand side of the column where we stand relative to the 287 corridor, the Meadowlands, different market shares of office types of uses. And what we've identified here in just these raw vacancy numbers was about 22% vacancy. That's a very high percentage when you look at the amount of office space that we have in the community. Since that time, I know certain things have improved, but yet that was an important feature to recognize and address in the master plan document. You'll see in a moment when I talk about some of the goals and objectives. In addition to that, we did a series of demographic analysis from the 2000 to 2010 census findings. And in that, some interesting findings was that Parsippany Hills population exceeds 50,000 people for over 2 consecutive census periods. It actually increased by 0.5%, not point, but 5%. How that compares to Morris County grew in that same time period by 4.7%, New Jersey by 4.5%. Really in line with the rest of the state and the county. The median age, as everyone knows, with the aging of the baby boomer population, the increase obviously affected Parsippany. The median age grew from 37.6 to 40.5 years in age in 2010. 18 years of age decreased from 21.8% within the community to 20%. It has to do with less children in the household as a result of demographic changes. 55 years of age and over increased from 21.9% to 27%. Again, you can see the same trends indicated by that percentage. Also, relative to housing, 91% of the residents were in the same house in 2011 as the previous year, showing retention of the house and people staying within the community. Average household size decreased from 2.59 in 1990 to 2.53 in 2000, but yet back up to 2.58 in 2010. Some of these trends you may find are interesting, may not exactly reflect existing conditions. There are some error factors relative to the census findings. So there are things of that nature to keep in mind in the data that's in the report. Detached single family over 52% in 2010. It's down from 56% in 2000. So the amount of attached residential housing has increased. Median value, though, for single-family homes doubled since 2000, when it was $234,000, and it's up to $415,000 in 2009. What's also interesting and important that the planning board pointed out, they wanted to make sure that we understood and had that additional snapshot of the relationship of renter-occupied to owner-occupied. How does that mix lay out within our community? Approximately 60% is owner-occupied in blue. What you see is also in vacant, according to the 2010 census, is 4.7%, but yet renter is 35.5% of the overall makeup. Again, median income is $125,000, which is up from $68,000 in 1999. 40% of the households earned over $100,000 in 2010, whereas 28% were in that same component. More than half employed in management. I keep pressing that wrong button. 80% of the township commuters drive alone to work, similar to Morris County at 79.1%. About 4% of Parsippany commuters use mass transit, similar to Morris County at 4.7%. Similar to those trends. As far as other economic findings, the unemployment rate from 2007 to 2013. We all know with the economic downturn in 2007, it brought on a significant increase in unemployment. That's actually played out in this chart. What you're seeing in the light green is New Jersey. In blue is Parsippany. We had a pretty significant spike in that same time period. And then Morris County is shown in the lower red column as well. And it was important to the planning board to identify that and place that within the master plan. Again, under the goals and policies, municipal master plans shall set forth a statement of objectives, principles, assumptions, and policies. You may have heard me come and speak to the council at earlier meetings regarding whether or not something is consistent or inconsistent with the master plan. And primarily what we're looking at is the goals and objectives. The goals and objectives outline the direction of land use planning within the community. We have 12 general objectives which are consistent with the MLUL, the purposes of zoning. In addition to that, we also have 12 goals and related policy statements. Several are reaffirmed from the 2004 report, whereas some are modified and a new issue is addressed relating to this development. Goal number, I'm going to touch on just a few of those. I won't go through all of them, but on goal number 3, provide a variety of housing types, densities, and a balance of housing supply in appropriate locations to serve the township. In this, we've also added in blue is that the township contains a broad and varied housing stock, but not the plan for any more multifamily housing. We had added the exception at the bottom where it accepts where it is determined to be the best interest of the township. What we found is that that goal needed to have some flexibility within it because of the relationship of where you may want to see and direct housing within the community. In addition to that, in goal number 3, should additional residential housing alternatives be sought by the township to meet changing township demographic or other conditions, and such development be located in established centers of development in close proximity to mass transit or other services. So it's important that we identify that so that the planning board and the zoning board, as well as the council, have those tools to direct the proposals or requests for changes to the land use code. We also note under that same goal that, in addition, such development considerations should be planned on balance with the needs of adjacent land uses. Issues such as, but not limited to, traffic, infrastructure, environmental impacts, and the like are also identified. And what's important about that is we're putting those features and pieces within the master plan so it gives the planning board and zoning board tools to work with as they're reviewing application. Number 8, to ensure that traffic and pedestrian circulation issues are affirmatively addressed in a local, and a regional scale. In that same goal, we have a policy statement where an excerpt from that policy statement is that expansion of pedestrian and bicycle connections into property to promote alternate means of access is a specific objective. It's very important to the planning board that we put this objective within the master plan because we're trying to encourage sidewalks and connectivity between properties, not just relying on automobiles for that connectivity as well. And this is the new goal that we've added, and this is to help address some of the issues of the vacancy of the office infrastructure that we have within the community, as well as the SED zones, or the Special Economic Development Zones. And in this goal, we've added to preserve and enhance the township's corporate research and professional office zones, implementing land use objectives that improve marketability and versatility in the real estate marketplace, while considering creative alternatives that are deemed appropriate on balance, again, with the township's land use planning goals. And the purpose for that is so we have the flexibility in the language. We're trying to encourage adaptive reuse, creative reuse of office markets. Joe Burgess, my partner, just came back from Seattle. A main focus of the National Conference on Planning was about reuse of office buildings. There are many, many communities that are struggling with this very issue. And so it was very important to the planning board that we undertake and incorporate this type of a goal within the master plan. In addition to the goals and objectives, we also identified amendments to regulations in the zone map, update checklist requirements. A number of these things will seem more rudimentary or detail-oriented. But yet we also looked at the other zones where, for instance, the OT zoning district, we're considering hotel as a potential conditional use with the proper setbacks. We've had requests for that type of use in that zone. The B3 rezoning, 4 lots along Parsippany Road, are sort of a gap in the zone plan. So we're looking at the potential for that connection. Disaster recovery facilities, the RCW zoning, we're making recommendation as well. The ROL zone properties along Route 10, we were considering some other reuses that could also occur for that same office infrastructure that exists along Route 10 as another feature. We have some obsolete zones, delete public and nonprofit dividend housings, where it's been in the code for many years, if not 2 decades, and it has not been implemented. So we feel it was something that has become an obsolete use. The APRD district actually no longer exists on the zone plan, but it exists in our zoning ordinance. So here in the master plan, you can see how the tool works. We can use this as making recommendations for changes. Also adding other service and instructional uses, personal service establishments, adding additional customary home occupation uses. I'm skipping through some of these. Individualized instructional sports training facilities. And again, as the landscape of use changes over time, we're trying to adapt to that so that we can stay in front of the needs of some of the business owners that are looking to reoccupy some of our existing spaces. Another major issue that has also come to light, I know the zoning board dealt with this, is adult daycare centers. With the aging of the population, people are looking for ways of helping with their aging parents, things of that nature, or aging loved ones that need adult daycare during the daytime. And we're finding that that's a specific use that we should consider also in certain zones where it's appropriate. Also, stormwater management regulations. We're trying to encourage more infiltration of stormwater, more treatment of the water quality of runoff from projects and properties. And that was a very important objective also for the planning board. There's also sustainable building and site initiatives, and I'll just skip through some of these. We're also talking about solar and wind generating regulations, off-street parking requirements as well, improvements to those. Sign requirements, little tweaks to the sign ordinance, temporary storage units and carports, the circulation element, trying to update that so that that represents a more contemporary standard. Also what are called streetscape improvements, which are sidewalk-style improvements maybe for the Lake Parsippany community along Parsippany Road. in those areas where the sidewalk is really not indicative of a downtown business district. There's an area where we think we should focus some effort on making improvements. What we've done in other communities for this very issue is actually to incorporate standards in your zoning ordinance, so that when a new development comes in making improvements, you have standards so it looks like it's uniform between property to property. Things like that that can improve the look and function of the streetscape. And again, you can see the list goes on. Noise and performance standards, accessory structure setbacks on corner lots. There's issues of simple things like people with condensers or air conditioning condensers that are now having to go to the zoning board for a variance when it actually exists within a front yard on the side of a house. We're doing little things like that to make changes within the regulation. And then also definitions and then other regulations relating to various features. In addition to that, we've also made changes to the zoning map, land use plan maps, as I mentioned earlier, updates to reflect the rezoning of some of the RCW, as well as the O2 zoning districts. And again, what's required by statute is that your land use plan should show your redevelopment areas. And I know the council has dealt with this issue, is actual redevelopment areas. You're required by statute to identify those on your land use plan when you update your master plan. And the land use plan, this is again the roadmap for the community, showing the various litany of various uses. And again, these are categorized by general topics. They're not the actual zones, but they're recommendations for where the zones should exist. One of the things I wanted to just quickly address for the council tonight, and I know Mr. Inglesino touched on this at earlier meetings, is the new what I'm going to consider as a new master plan issue. And this has to relate to affordable housing. The Supreme Court ruling in March of this year, March 10th, had identified that COA is no longer effective, the Council on Affordable Housing. That is the agency by which all municipalities were able to rely on for a need number for us to plan for what's called affordable housing. With this new ruling, there is actually a change now. The courts are now taking back the review of housing elements and fair share plans. Where Parsippany was back in 2008 to 2010 is that we were addressing the third round plan, and that's the current cycle that we're in of affordable housing. In that third round plan, we submitted a third round plan for certification by COA, and this was something that the council by resolution sent it to COA for certification. Since that time, the third round rules were overturned. We now have to address an issue called fair share instead of growth share. Going back to prior rules or prior requests or recommendations for affordable housing. But that now the game is going to be with the courts, and we need to submit two different approaches to the courts. The first step will be a declaratory judgment step, which is due by between June 8th and July 8th of 2015. It's basically a legal submission of current and past efforts. We will be submitting the prior housing element to show our efforts to try to get certified and meet the affordable housing requirements affirmatively, but that it will also be reviewed for other things you may have done, such as, bless you, group homes. Some of the group homes that we have also authorized with the Housing Trust Fund money. We're going to be indicating those efforts, use variances that have also realized affordable units. We'll be sending all that information down to the courts for them to identify that, yes, Parsippany has been participating. And that from that time frame, as you'll see in the next item down, the timing is for a 5-month period for a new plan. What is not clear in the rulings is where that 5-month period starts. We're anticipating it will start from July 8th of 2015. The courts may in fact adjust that, but that is our current thinking. So we'll need to be very proactive and aggressive about how to address that issue. What's actually being identified is that there's going to be a regional need number. Instead of it just being a growth share based upon how Parsippany grows, it actually will be a regional need for affordable housing, which is going back to the second round rules. And it requires an overall uniform approach. The courts really haven't addressed that issue. There are a series of approaches to that. One is where the courts requested COA to prepare a fair share housing need number based on the second round requirements. That number was about to be released, but then a council on affordable housing chose not to adopt those rules. So therefore, that need number is really not official. It's not an official number. But just to give you an idea between what calculations are currently being contemplated, is that the Fair Housing Center, which is an advocacy group for fair housing, as well as the Builders Association, have both commissioned their own studies as to what is the overall regional need, as well as looking at what the individual allocations may be for municipalities. What's identified is that the overall fair share for the state ranges wildly between 41,000 units to 300,000 units plus. So there's a real disparity between.
Ed, what's the 41,000 based on in the 310? Because I sat in a COA seminar yesterday. Mr. O'Neill was there, and other leading attorneys and planners.
Right.
And what I heard was somewhat concerning, because while the fair share housing folks and the builders have commissioned experts who have come up with both regional needs and needs on municipal basis. And by the way, the Builders Association has Parsippany at 1,100, and the fair share, I'm going to get the number, it's something similar. I also learned yesterday that the League of Municipalities has not commissioned an expert.
That's right.
And probably will not be able to commission an expert to provide similar numbers. So where does the 326, where does the 41,000 come from, and where does the 326 come from?
Certainly. Yeah, Dr. Burchell of Rutgers University, he was the one that was commissioned by COA to prepare the fair share housing numbers.
But
based
those
on
were
the
that, but that wasn't based on second round methodology,
Yes,
was
it
it?
was. Yes, it was. His numbers were in fact based on second round methodology.
Okay.
And that is actually something that Joe Burgess from my office, he and I had a conversation this afternoon. He talked with Dr. Burchell out in Seattle at the convention. And there's going to be additional discussions about where those numbers came from and how valid those numbers are. Because the debate's going to be is how you arrive at that overall need number. And that's what the difficulty is going to be. As you can see, as you appropriately pointed out, is a large disparity between the
And Dr. Burchell, by the way, would have been a person, would have been ideally situated to represent the league, and because of a conflict, because he worked for COA, apparently is unable to do so.
Correct.
And so the reason why the league doesn't have an expert is because there isn't anyone who has that baseline knowledge that could do this on a statewide basis. Not necessarily that they couldn't come up with a number that would rival the numbers put out by the builders and by the fair share housing folks. But without an expert by the league that can give the same kind of statewide guidance that the builders and the fair share housing folks have, it seems to put municipalities at a little bit of a disadvantage in the sense that we don't have those same resources.
I agree with you. I agree with you. It's going to be difficult and a significant challenge for most communities.
Now, the other, just so everybody's straight, when the declaratory judgment is actually a legal proceeding, it's a lawsuit that we would file, and we would be asking the judge to do a couple of things. Number one, we would be asking the judge, if not in the initial submission, at some point in time in the future, to affix what Parsippany's number is. What is our affordable housing obligation? And again, as I indicated last time, I said approximately 400 and approximately 1,100 or whatever it was. It's going to be somewhere between 326 and 1610.
Right.
But it's going to be significantly higher than it is now.
There's also a maximum cap number, which is 1,000 units.
Right.
Sort of a mercy rule.
Right. Well, the Supreme Court didn't adopt the
I know that.
mercy rule.
But yet
there's
some discussions about
Well,
whether or not
but
there
there's
was
not a mercy rule. There's discussions of a potential cap. But let's just, the law is
Understood.
there's no recognition in the Supreme Court decision that there's a mercy rule.
Right.
And so the first fight, or whatever you want to call it, proceeding is going to be around what is our number. The second issue is going to be, where do we plan and put those numbers? And one of the issues I see with the master plan, it may sound good politically to say we don't want any multifamily housing, but I got to advocate. How do you defend in court that Parsippany is committed to meeting its co-obligations, and in the master plan, a goal is no multifamily housing.
Except where appropriate. That's
Well,
why we
except
added
where
that
the best interest of the township, and there's no goal in the master plan for Parsippany to comply with its affordable, constitutional affording housing obligation.
Well,
and so-
that's where the housing element comes from.
Right,
That's-
but
that's-
we're going to have to
right.
deal with that,
Right.
in a way that portrays Parsippany as making a good faith effort to comply, as Parsippany has done in the past by participating, in the COA process. By the way, the other point that came out yesterday in terms of establishing the number and why Parsippany's number is high, as I understand it, relative to a lot of other municipalities in Morris County, is number one, you look at availability of vacant land. That's one of the factors. So the more vacant land you have, the higher number you're going to owe. So if you have vacant land, as you do in some instance, that is not only going to drive your number up, it is also going to make that vacant land very susceptible to unwanted development. Number two, they're looking at the number of job opportunities there are in municipalities. Parsippany made a conscious decision back in the 80s to develop an enormous supply of office space, which provides employment opportunities, and in putting housing next to employment opportunities, that has also driven up Parsippany's number. And the other thing that's driving up Parsippany's number is a wealth factor. And compared to the rest of the state, congratulations, you're a wealthy town, therefore you have to have more affordable housing. The other point that was made that was very interesting, and I'm sure Mr. Homiak's going to have a comment made on this, is that the Highlands has served to increase affordable housing obligations in municipalities such as Parsippany, because in the Highlands, in several hundred thousands of acres, there is no development permitted. But the regional need is the same. So you have to build more affordable housing in more concentrated areas and in municipalities that are not in the preservation area. So the eastern Morris County municipalities in particular have been hit hard with an additional burden of affordable housing, because there are other areas in our region that are not developable. So it pushes that obligation, that development obligation, into municipalities such as Parsippany.
Correct. And as you mentioned,
If you want to reinterpret that, okay, we have adequate water, sewer, and roads.
Right.
Harding Township, which truly has exclusionary zoning, okay, they're not a part of this, because they don't have a sewer system, they don't have a water system. They have wells and septic. Does not lead to cheap construction. So they get waived from all of this, and our towns get whacked all the time. Just want to make one more comment, observation. When the courts had control of this in round one, which I was involved with, the courts, experts, I use that term loosely, calculated how much vacant land we had in Parsippany. And in their calculations, they included lots in between two houses. And they added up all of these lots and all of these broken up pieces of property and came up with one nice big number and said Parsippany should develop 4,000 moderate and low income units in Parsippany. That was the original number we got from the courts, 4,000 units. And using the builder's remedy, the builder could build 4 high income for every 1 low income. So that was 4,000 moderate low income, 16,000 high income. 20,000 units was the original number the courts came out with that Parsippany was obligated to build. That was bigger than the entire town. Add up all of our garden apartments, our homes, our townhomes. That was larger than all of the rest of the population we had at that time. And that's what the courts started with. And we fought that in the courts for years, and we got those numbers reduced because they were stupid. They were idiotic. And I'm afraid now, the courts are taking us back, and we're going to see remnants of round one.
It's going to be a challenge, and we'll have to be aggressive, definitely, with our responses to that. And one of the things we're going to be looking at is what's called, as John was alluding to, the realistic development potential, which is really looking at your vacant land, also what is the developable vacant land? Not just vacant land like Troy Meadows. We have vacant land that we have to make sure is in fact developable. So we're going to be very aggressive, and I think some of the new information that we have will help us with that analysis as well.
Excuse me, Ed?
Yes,
You
certainly.
just had mentioned it. How much vacant land is left in this town?
Well, that's
This
something I'll
evaluation.
have to take a look at, because you're asking from the question of really developable land.
Yeah.
That is a difficult question to answer off the cuff, because you have to look at and factor all the steep slopes, wetlands, buffer areas, things of that nature that I'll have to back out.
Well, we have 26 acres on Waterview.
Yeah, that's.
Well, and the challenge on Waterview is that it is a developable piece of property. Obviously, we went through a procedure in which the development of the property for multifamily housing was determined to be appropriate, and in densities, that are meaningful in terms of your overall, housing. I mean, the developer is suing right now. He wants 600 and some odd units. I don't think we think it's appropriate. It could be developed that intensely, but certainly I think the number that was in the record was somewhere around 250 or so. And you take 25% of that. That's a chunk of units, and that's just one of the factors. So you're going to get an obligation, whether it's 326 or 1610, which is probably going to be, although Ed's going to do the analysis, well in excess of the vacant land that is available for those units to be constructed, which is going to put existing tracts of vacant land at significant risk of unwanted development that you're not going to be able to control, which goes back to the point that Councilman DePiero made back in November of 2012 or whenever it was. What is your ability? Under that scenario, it doesn't matter how the property is zoned. That's the whole point of exclusionary zoning. The zoning that you have in place doesn't matter. And, that's going to be a real significant challenge, even assuming a best-case number of 326. But Mr. Snikes is going to have to do the analysis to see how much vacant land you have, but
Yeah,
that's
when
going to
can
be
you
tough.
get us that answer, or do you have an average of
I
how
can
much
get you
vacant
that
land?
answer next week.
Okay, that'd be great.
Yeah, absolutely.
If you could send that to, the council so we just have an idea.
Certainly, I can
Okay.
definitely get you that.
All right, thank you.
I'd much rather have an accurate number than a speculative number.
Okay, thank you.
What would be the actual one? I mean, you're from 326 to 1610, that's affordable housing. But what does that really calculate to housing total?
You have to
Times four,
multiply that
right?
times 5.
That's 6,440.
6,400 units or so.
So that is the equation. It's 20% set aside normally, unless we do things like 100% affordable.
Well, under the
development.
builder's remedy, it's 25%.
Yeah, that's true too.
It's one,
That's
it's
true, too.
one,
That could
it's
even be
one,
worse.
it's because you're talking about a builder's remedy situation when you're doing the mayor's calculation, so it's,
Actually less.
you're
Yeah.
multiplying it by 4.
4. Right, but then we'll also look at other vehicles where we'll try to do 100% affordable units. All the group homes that we have, we actually get a bonus for those group homes. Rental projects, you get bonuses for as well. So we're going to be looking at using all those tools creatively in order to address this issue.
And any credits that you may have left over from the
Right.
prior rounds.
We have 152 credits from the prior rounds.
Ed, I have a
That's
question
something I
for
wanna
you.
look at as well.
A couple of years ago, we were talking with the developer that was going to build on Edwards Road near New Road. And the whole area behind the Wawa was going to be a detention basin. Now, that property was never, that project apparently never moved forward.
Actually, no, it is moving forward.
Is it?
Far before
Yeah.
DEP.
Redevelopment zone was
So
approved.
then the question I have is, that property that behind the Wawa, which is going to be a detention basin, can they include that in their calculation of open space?
No, developable land? No, because that area is wetlands now. What they're looking to do is modify that wetlands for greater storage capacity for the flooding
Right.
issue, but also improve that wetland to a more viable wetland as well. So, no, that would not work into your
That's
realistic
good.
development potential. But remember, that site also had a set-aside. We made sure that that site was going to be inclusionary as well.
Yeah, and one of the policy decisions that the council should probably undertake in the future, depending upon Mr. Snikes' analysis, is perhaps enacting an ordinance that would set a requirement of inclusionary development for any multifamily housing that comes into town, so that you're assured of getting closer to your target. And from a new housing element perspective and an affordable housing plan, that's something that the courts are probably going to want to see. The only other point on vacant land is that many times, and I'm sure cooked into that 1610 number, is vacant land that the affordable housing folks and the builders believe that can be built on and probably is not developable.
Correct.
And so what would happen in COA, and what I suspect will happen here, is that we'll go in for a vacant land adjustment.
Correct.
Which says that, look, you may have said Troy Meadows is developable, but it's not. So you got to take that out of your, factors in terms of calculating what our obligation would be. And by doing those kinds of things, you can begin to whittle your number down.
Exactly.
I'm sure that those are the kinds of exercises that Mr. Snikes has to go through to get to a number that he feels that is supportable.
One more question.
Yes.
The Wildlife Preserves property that we rezoned to RCW, can they count that? The Highlands portion of Wildlife Preserves?
It depends on the outcome of the lawsuit. Right now, we're
that we say that.
yeah, the answer at the moment, Councilman DePiero, is no, it's not developable because your ordinance enjoys the presumption of validity. However, a lawsuit's been filed challenging the ordinance. We're in the process right now of engaging experts, and that's going to be fought. And so the answer depends upon the outcome of the lawsuit.
And also, with the verbiage of looking at the master plan, does it indicate that we did address the housing needs?
Yes, in the earlier elements, housing elements of the master plan, that's what they're called, housing elements and fair share plans, is they in fact affirmatively addressed the housing need, first and second round. And we've been going under the prior round certification for
Right.
that second round.
And when
Now
they go,
the courts are saying, now we have to deal with the third round. Now we have to move forward. We may have to amend the master plan in order to reflect any of the changes to address the third round requirement.
will it also take into consideration excess demand that we created through high-density development?
Absolutely. One of the things that I'll be looking at is gaining all the credits that we can get for anything that we may have approved and/or that exists, such as, let's say, the senior housing developments, where we have a number of them that meet the requirements of COA, that we're going to try to apply all the credits wherever we can. There will be limits to those applications because there are caps on certain numbers based on your overall need.
Right, Edwards Road was brought up, but that was a redevelopment plan back in 2003.
Right.
And that was slated for high-density housing.
Correct.
Would that help as well, since it's already earmarked for high density?
Yes.
Okay.
But yet high density with an affordable housing
With
set
the
aside.
affordable housing
Gotta
set aside.
be inclusionary, and that's what I think Mr. Inglesino was pointing out earlier, is I would be a supporter of an ordinance that says if we're considering multifamily development, there should be a set aside associated with that.
And where are we
That
with-
you're gaining the credits appropriately.
And where are we with that project right now on Edwards Road? Because it's been since
Well,
2000.
first of all, I don't think we have a redevelopment plan yet.
Not yet.
We have a blight determination.
Light determination.
And there are significant DEP permitting issues. The lawyers who represent that developer have kept me apprised on a periodic basis as to what their progress has been. It's been slow.
That's K. Hovnanian.
There is some movement, but the permitting issues are significant. And so until those permitting issues are resolved, the project will not go forward. Then they have to come in for the plan. That project in and of itself is not large enough to be a panacea, but it will certainly, provide an opportunity, if you approve it, again, to start to whittle away at your obligation. And that's why it's important that whenever you have a multifamily development, you have to include an affordable component within that project. Otherwise, you're not addressing that need in the way in which you should be able to.
Ed, you stated that we currently have 152 credits.
Yes.
So does that mean we exceed our requirement right now by 152?
there's what's called carryover credits. So because of past activities, contributions, what are called regional
Right.
contribution agreements in Newark, we do have credits that we have assigned that we can actually move forward to the third round that
Okay.
we're looking to gain credit for. It's going to be a question, though, of applicability. How much can you use of certain types of credits? that you
Or
have?
whether what the courts are going to accept is
That's
going to
gonna be
be,
another-
was going to be an open question. So we're going to put forth the arguments for accepting all of the credits.
Correct.
Whatever they are, and we're going to make those arguments. I'm sure that the builders and the fair housing folks are going to put forth the arguments as to why we shouldn't be, and any other interested party, like RD Realty, who is an interested party, and as we've already been served with notice on that. They'll put forth the arguments why we're not, and the court's going to have to is going to have to make a call. The problem, one of the real challenges for us is that there are no rules. You know, the courts now are going to make up the rules, and so we don't know what the judges are going to do. At least when COA was around, you had rules and regulations where that you could plan for the rules, and you know you could plan on how you wanted to follow the rules, and so you had control. You know, kind of the unknown here is the fact that we're doing this in a vacuum, and we don't know what the courts are going to accept and what they're not going to accept. And there's no uniformity statewide. Everything's going to be decided on a judge by judge basis, which sounds kind of crazy, but you know that's where we are.
We see the rules being adjusted case by case as it goes forward. And
Ed, I know we've been working on our spending plan. That'll be a part of it, that, you know, that we aggressively did pursue with the various entities that made up that plan.
That's
And as you know, we've been involved in doing that. And I think that should count for something, that we didn't say, okay, we just made up a plan just to hold on to the money. We've
Absolutely.
actually invested in that.
I strongly feel
Yeah.
that those types of things will be used towards a declaratory judgment.
Absolutely.
And get us that 5 months.
Yeah.
Well, that's important point,
Yes.
is that I
Yeah,
think
that's
for
why-
those municipalities who have been doing the right things, like Parsippany, adopting the plan based upon the rules that were in existence, getting extra credits, and even in the status of COA's dysfunction, we were still using Affordable Housing Trust Fund to, to create more affordable housing units with the nonprofits. And I think that because Parsippany has acted in a model kind of a way, that you would hope that the court would say, you're going to get a judgment of immunity. That's one of the things we're going to be looking for when we file our declaratory judgment, is we're going to be looking for a judgment of immunity against builder remedy lawsuits for that period of 5 months. I don't think every municipality is going to get that. You know, those municipalities who have had their head in the sand, judges may be much tougher with them. But, one of the things that we've asked Ed to do is to pull together and really create a narrative for all that Parsippany has done over the years, and to use that in a way to show that Parsippany has been a good municipality in terms of Mount Laurel compliance, and use that as a basis to say, hey, Judge, we need a period of time in order to decide on our number and come up with our plan.
Correct.
Well, I hope you're not painting a rosier picture than we're going to really see. Because my memory goes back to when they had the judge assigned to northern New Jersey to enforce Mount Laurel housing years ago, round one, okay? He told us that the 7,000 apartments, the 2 senior citizen complexes, the high-density housing that we have in Rainbow Lakes, in Mount Tabor, in Lake Hiawatha, and segments of Lake Parsippany, okay? None of that counted. And he said that his job, this is the judge speaking now, his job was not to render fair and impartial hearings. His job was to enforce Mount Laurel and the numbers that they have to come up with.
Well, and that's right. The judge's job is going to be to carry out the edict of the Supreme Court. And, we're going to advance all of the arguments and advocate forcefully for a lesser number. We're going to have adversaries who are going to argue the opposite. And we'll see where the dust settles. But, I think that obviously there's considerable risk whenever you're leaving a decision up to a judge. And, you know, the history.
That was my point.
And there's a history here that, you know, and there's a regional need. And, you know, one of the concerns that we're going to have to address and look at is, you know, that while a judge is going to be looking at assigning your number or sanctioning your number, it's going to be viewed in the context of the regional need. So the larger the regional need, you know, the more likely the judge is going to say, you know, tough municipalities, you know, I've got to allocate a regional need. And when you have so many, you know, the Highlands really hurts Parsippany in that regard because it forces affordable housing here where it could have, if the Highlands law was not enacted, could have been dispersed over a much larger geographic area.
That actually summarizes the presentation, so thank you very much.
Thank you, Ed.
Thank you, Ed. Very good,
Great job.
very timely.
Ed, thank you for coming. I appreciate it. When I requested you to come, I really wanted an overview, and you did a great job. You know, the master plan is really the keystone to municipal planning, and, you know, you don't have to say any more. That's the most important tool that we have available. Specifically, we're talking about COA right now to help us as well. But as far as the plan when it was put together, did you include working with the committees? I know I'm on the historical committee, and I know you included a lot of the houses for historical purposes. Did you work with the other committees as well, or any outside organizations such as
We did seek
economic
input.
development?
We did seek input from those committees, but yet the historic committee was the one that I think came to us the most, came and showed us their updated list of historic homes, potential historic properties. We did include that as an appendix
Right.
to the master plan.
Okay.
So it's in an easy lookup table, basically, for the planning board or the zoning board as they're
Right.
considering an application that may affect one of those pieces of property. So that was definitely.
Did you also consult with the county at all, Morris County Economic Development, when you were talking about the vacancy rates and the economy?
Not with the county, but we did go, I personally did partake in several of the meetings of the Economic Development Authority and understanding and hearing from the various retail entities, the real estate entities that were identifying their need for adaptive reuse of facilities, being creative about office building, things of that nature, and that did play into my discussions with the planning board.
And the numbers I see for the vacancies that we have, they seem a little bit high right now. Are those including indirect locations as well as direct properties?
What you're seeing there is probably just the direct, at 22%.
Yes.
It actually doesn't include what's called shadow vacancy.
Right.
Shadow vacancy is where someone's leasing a space but not necessarily occupying it.
Okay.
And so that could easily account for another 5 to 8%.
One more question for you, Ed. Forge Pond.
Yes.
The township is supposed to acquire control over 130 acres, including the pond and surrounding land. We haven't done that yet. Would that 130 acres be included in vacant land?
Highly unlikely because of the environmental restriction that we have on that, except for there is one section of upland areas that I think we were contemplating for a sports field or some sort of use, active use, let's say, that location may in fact be identified by the court.
But if we take control of that 130 acres and call it open space, then it's out of the picture, right?
Yes, one of the things that we're looking at as well is updating our ROSI list. The ROSI list is the Recreation and Open Space Inventory. What that does is it allows you to identify properties that are acquired with open space trust fund monies, and that then obligates them to be used as open space. So that is something that we're also looking at as another tool to address the issue of vacant land.
Okay, thank you.
Okay, thank you.
Ed, also one additional question on the wellheads that we are protecting right now. You put in there some suggestions requiring the design of irrigation systems. Is your concern that we may have a water shortage as we have in past years where we had a drought situation?
Yeah, typically you see your highest demand in the summertime for water usage.
That's your peak usage.
Your peaks are right around June, July, and August. And that what we're recommending and trying to encourage in projects that get submitted is the idea of what's called xeriscaping, which is reducing the water demand by the landscaping, but at the same time incorporating drip irrigation systems, timers, water sensors. A lot of the industry improvements have been dramatic in this area I think California's probably been leading the charge, obviously with their significant drought that they're experiencing.
Is there a concern with future projects with the amount of water that we have available?
There is a concern from my side. I just want to make sure that people are being creative in their sustainable approaches to the development, whether or not it's also incorporating not just those other features, but reducing the amount of turf area. I think it's becoming more accepted in the corporate environment to have some meadows
Right.
in front of developments instead of large plush lawns. Those plush lawns require not only irrigation, but fertilizer, things of that nature,
Sprinkler
higher
system.
levels of maintenance, more fuel usage to mow it, things
Right.
of that nature. So we're going to be looking at techniques such as that to incorporate.
Just on a side question, since we're talking about water, Wegmans that's moving into Hanover, which is on the borderline of Parsippany,
Correct.
did we sell them water?
I don't know that for certain.
Well, they have to get the water from us.
They are getting the water from us?
Yeah, they're in your water district.
Yep.
Yes.
So the council passed, I forget whether it was a resolution or an ordinance, probably 2 years ago or so, to provide water over there.
Yeah, but we had a prior commitment to do that.
You had a prior commitment to the office building over
Right.
there that had expired. but
Okay.
Notwithstanding the fact that had expired, you have plenty of water.
Okay.
You really weren't in a position to be able to deny them the water. If the Wegmans actually is a project that comes to fruition.
Yeah, they already did the tree clearing on it, so there's a project coming in. See what happens. Thank you, I appreciate your time.
Thank you very much.
Thank you. Okay, bids to be taken. May 6, 2015, 11 a.m. Seal proposals for the roadway improvements to Robin Hood Road, Friar Road, Exeter Street, Sherwood Road, Hastings Road, Crawford Road, and Little John Road. May 7, 2015, 11:30 a.m. Electronic bid submission for electric generation service. Requests for quotations, proposals, qualifications, April 22nd, 2015, 11 a.m. Seal proposals for fireworks display services, May 1st, 2015, 11 a.m. Sealed qualification statements for risk management consultant, liability insurance broker of record services. Okay, ordinance number 2015
Colin 03.
03.
An ordinance establishing hourly wage ranges for blue-collar supervisor employees of the Township of Parsippany-Troy Hills, 2015-2018. The notice for the ordinance above was published in the Daily Record, the official newspaper of the Township of Parsippany-Troy Hills, on March 24, 2015. Motion to accept that ordinance.
Second.
Motion by Mr. DePiero, seconded by Mr. Stanton. All in favor?
Aye.
Opposed? This time, entertain a motion to open up the public hearing for this ordinance and this ordinance only.
So moved.
Motion made by Mr. DePiero, seconded by Mr. Paluso. All in favor?
Aye.
Opposed? Okay, see no one come forward. Entertain a motion to close the public hearing for this ordinance.
So moved.
Second.
Motion made by Mr. DePiero, seconded by Mr. Valori. All in favor?
Aye.
Opposed?
Whereas the above ordinance was read in title on second reading and the hearing held thereon, now therefore be it resolved that said ordinance be passed on final reading, and that a notice of final passage of said ordinance be published in the newspaper according to law.
Second.
Motion made by Mr. DePiero, seconded by Mr. Stanton. Roll call.
Mr. DePiero,
Yes.
Mr. Paluso,
Yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes. Ordinance number 2015:04.
An ordinance amending ordinance 2014:17 entitled, "An Ordinance Establishing White-Collar Salary Ranges for the Township of Parsippany-Troy Hills." The notice for the ordinance above was published in the Daily Record, the official newspaper of the Township of Parsippany-Troy Hills, on March 24, 2015. Motion to accept that ordinance 2015:04 be heard in its second and final reading by title only.
Second.
Motion made by Mr. Paluso, seconded by Mr. Valori. All in favor?
Aye.
Opposed? This time, entertain a motion to open up the public hearing on this ordinance and this ordinance only.
Motion.
Motion made by Mr. Paluso,
Second.
seconded by Mr. DePiero. All in favor?
Aye.
Aye.
Opposed? See no one come forward, entertain a motion to close the public hearing for this ordinance.
Second.
Thanks again, Ed.
Motion made by Mr. Valori,
Second.
seconded by Mr. DePiero. All in favor?
Aye.
Opposed?
Whereas the above ordinance was read in title on second reading and a hearing held thereon, now therefore be it resolved that the said ordinance be passed on final reading and that a notice of final passage of said ordinance be published in the newspaper according to law. Motion to approve the resolution.
Second.
Motion made by Mr. Paluso, seconded by Mr. Stanton. Roll call.
Mr. DePiero,
Yes.
Mr. Paluso,
Yes.
Mr. Stanton,
Yes.
Mr. Valori,
Yes.
Mr. Karifi.
Yes. Stanton.
Ordinance number 2015:05, an ordinance of the Township Council, Township Parsippany-Troy Hills, County of Morris, State of New Jersey, to amend supplement Chapter 290 entitled Parks, Recreation Areas, and Public Lands, Article 1 of Dakota Township, Parsippany-Troy Hills. Notice for the ordinance above was published in the Daily Record, the official newspaper, Township Parsippany-Troy Hills, March 24, 2015.
Second.
Motion made by Mr. Stanton, seconded by Mr. Valori. All in favor?
Aye.
Opposed? This time I entertain a motion to open the public hearing on this ordinance and this ordinance only.
Make a motion.
Motion
Second.
made by Mr. Stanton, seconded by Mr. Paluso. All in favor?
Aye.
Aye.
Opposed? See no one come forward, entertain a motion to close the public hearing for this ordinance.
Make a motion.
Motion made by Mr. Stanton, seconded by Mr. Paluso. All in favor?
Aye.
Opposed?
Whereas the above ordinance was read in title on second reading, a hearing held thereon, now therefore be it resolved, said ordinance be passed on the final reading, that a notice of final passage of said ordinance be published in the official newspaper according to law.
Motion made by Mr. Stanton,
Second.
seconded by Mr. DePiero. Roll call.
Mr. DePiero,
Yes.
Mr. Paluso.
Yes.
Mr. Stanton, Mr. Valori,
Yes.
Mr. Karifi.
Yes. Mr. Valori?
Yes, Council President, ordinance number 2015:06. I'd like to make a motion to carry that ordinance.
Second.
Motion to carry made by Mr. Valori, seconded by Mr. Stanton.
And why are we doing that?
It was at the request of the interested party, Mr. DePiero, so I would recommend that, I support the recommendation to carry it.
Okay.
Is it to carry to May 19th?
Yeah, you should just
Yes.
carry it to a date certain.
Roll call.
Excuse me. Mr. DePiero,
Yes.
Mr. Paluso,
Yes.
Mr. Stanton.
Yes.
Mr. Valori,
Yes.
Mr. Karifi.
Yes.
Yancy, that was May 19th, the second meeting
The
in...
regular.
Okay, thanks, the regular, thank you.
Before we go to public hearing, Mr. Inglesino, you were going to look into, I had asked a question last week if our insurance carrier was notified, had sent a letter, the administration had sent a letter to them notifying them that,
I would recommend, Mr. Council President, that we discuss that item in closed session under
Okay.
both legal counsel and prospective litigation.
okay. Okay, at this time, I entertain a motion to open up the public hearing.
Make a motion.
Second.
Motion made by Mr. Stanton, seconded by Mr. Paluso. Roll call.
Mr. DePiero,
Yes.
Mr. Paluso,
Yes.
Mr. Stanton.
Yes.
Mr. Valori,
Yes.
Mr. Karifi.
Yes. Okay, please state your name, address for the record, sign in. You'll be given 5 minutes.
You have to share probably, exhibit 2, and then share the books, and open up the page. The guy would take
Pass them around?
Yeah, but pass one at a time.
Okay.
It's gonna get confusing.
Okay.
Have them share this book, just leave this paper.
You don't have any.
I don't need to.
Okay. Pass it down,
I'm
guys.
sorry, for one for each person. I'm sorry.
It might not be enough, so you have
We'll
to.
share it first exhibit here.
We like to share.
Yeah.
I mean,
We'll bond.
This week.
Yes, sir.
Roy Messmer, 10 Drumlin Drive. Tonight, it's really not necessary for me to do this, but I want to share this with you, and I might be coming back to this mic in a future date to ask for your help on other matters with this. There was a state representative of ours that helped me with this, if you will. I brought it to this individual's attention. That individual's chief of staff made a phone call, I assume, maybe even John knows about this, to the state tax commissioner, and was pursued there. Again, I stumbled upon this about 3 or 4 months ago. I knew nothing about this tax reimbursement. I never really heard, I guess I kind of heard of it before, but I didn't know what it was about. What you have in front of you, in fact, I gave you my copies. Exhibit 1, probably need to run. That shows the can I just see Exhibit 1 quick, Paul? Just hold it up for me. Let me, okay, that.
Here, you can hold this.
Yeah, thank you.
Exhibit 1, as you notice, it deals with 2012, 2013 property taxes. Then go to Exhibit 2, page 1. It has the box changed. You check the box if there's been a tax appeal, a reassessment, or added assessment. How I stumbled upon this was that in the town of Parsippany, there are 1,400 homes that have their taxes frozen. 1,400. And I came across something where I knew of somebody who put an addition on their house, and it was an older person, and I said, you know what, like I said, I stumbled upon this, and I pursued it, and I've spoken to several tax collectors, several tax assessors in the state, and they go, wow, this is pretty big. Now, I'm not saying how many are in Parsippany, but remember, this is a program that's statewide. Obviously, people that live in Mendham, Chester, Mountain Lakes, Short Hills, I doubt if there's anybody in those towns that qualify for this program, but there might be. So this individual, and there's a couple of more in this town, or several of them, maybe even a couple of dozen, put an addition on their house. But people in this room, people in this town, are paying for these people to put their addition on their house. Because there's never been a check on the box like I had done this year for 2014, where the reassessment. So our tax assessor goes out, does a reassessment, but that person's getting that money back from us taxpayers. In addition to this, there's 2 other programs that I'm working on, if you want to call it programs, changed in this booklet, that if you have, it should be total income in that household, not just the person that owns that house. Because many sons and daughters are moving back into their mother's and father's house, and their parents' taxes are frozen. And number 3, if you're taking grandchildren or children back into your house, obviously children would be very unlikely, but grandchildren, and they're going into our school system, whether it be Parsippany or any town, your taxes should not be frozen. So the first step and the big one was what I got changed this year. Now, I'm not going to take full credit for it. I don't even like getting up here talking about this, but there might become a point in time, a year from now or whatever, I might come back here and I'm going to ask for your help, because it's not fair to the other people paying that these people are getting their taxes frozen, and we're paying for their tax increase. If you have any questions when I'm done next couple of minutes. I don't think I've got anything else to say on this. I took some love notes here, but those are the 3 items. One has been taken care of. And John, I know you have a hotline to the governor. If you could tell him about this, if he doesn't already know about it. This was done very quickly. I think even the books were held up for a month or so before they went out. The other thing I want to bring up tonight is regarding these group homes. We have 11 supposedly. What I like to see a state law done is that before any other COA money goes for affordable housing, that the COA money that's paid in by the builders goes to pay the real estate taxes on those homes. Again, not just for Parsippany, but for any town in New Jersey. And the reason for that is that we're getting whacked there too. People like the 5 of you, 6 of you, elected officials, myself, people behind me, we're paying, I'm sorry?
30 seconds.
We're absorbing that, where surrounding towns don't have as many affordable housing homes. And I know, Mike, you made a mistake. We all make mistakes. You thought they were paying some taxes some time ago, but
Yeah,
they're not paying one penny.
in lieu of taxes. I know the ARC did, because I was director of the ARC in Lake Hiawatha for 10 years, and they paid in lieu of tax.
They're not, Mike.
Maybe they're not now, but they were
Well,
then.
I don't think they were even then either. So we need to get that. John, do you follow what I just said on that last item?
Yeah.
Okay. Just go. Is that
10
it?
seconds. Yeah. 10 seconds.
That's okay. Good night.
Thank you,
How are
Rick.
those
Can I
Yankees
get those
doing?
back for you? You need them?
No, I do need the blue books back. And just
No, you
pass me
took
the
his
answer.
copy.
I gave you my
You
copy.
took his copy.
Mr.
Roy,
Mesmer,
before you leave, I
The
have
blue copy. The book. You got to get back to Yancey. He's got to get back to Dan.
Okay, but you have the 2 copies.
Yeah, that's what you want.
Yeah, I'll take them. Yeah.
Sure.
Oh, these blue books get back?
Yeah. Go back to Kansas City. I borrowed them.
Mr. Mesmer, I was prepared for you tonight. I apologize already to Ms. Patachia. I wasn't completely prepared for her. You had asked about the applicability of Opinion 575.
What's 575? The one with last week that I handed out?
Yes.
Yeah. Okay. I don't have it in front of me.
Okay, that opinion precludes freeholder attorneys from serving as public defenders in municipalities. My long-term memory is pretty good, because back in June of 2004, there was an opinion written on this by the Advisory Committee on Attorney Professional Ethics. And in that opinion, the appearance of impropriety rule for lawyers was removed, and so that the restrictions on the practice were lifted. And the opinion specifically references 575. So opinion 575 that you handed out is no longer good law and has not been good law since 2004. That is not to say that actual conflicts could not arise, because they could in any situation. But there is no per se prohibition against attorney freeholders serving as public defenders, or Board of Adjustment attorneys or utility attorneys in municipalities within their county. That ban was removed back in 2004.
Thank you, John. Yeah, you know how I am. I'm a gentleman. I bring it out forward. The other thing I do want to say, I didn't make a mistake. I got wrong information. At Westbrook, there wasn't skeet or trap shooting done there. I spoke to Mayor Letts. There was a property next to it. But again, I got that information from somebody. I relayed it on to this staff. Thank you.
Roy,
Thank you.
I think she did this one too. Yeah. Yeah, absolutely.
I'm back. Gentlemen and ladies, I'm back. It's been some winter, hasn't it?
Yeah.
We even had 3 major snowstorms in 1 week.
Ma'am, just state your name and address, please.
Excuse me?
Your name and address.
Oh, Beverly, I thought you were on the right now. Beverly Casper, 36 Normandy Drive. With the fire hydrant. Okay? Mr. Shovel would have come, but he has developed a fracture from being overworked this winter. But I'm back about the same issue. 1,000 fire hydrants on private property, while their neighbors sit in the house, watch the old girls shovel, and get paid money on a rebate for having that fire hydrant there. I think that's inequitable. But I've brought this issue to you before. What really surprised me this winter as I passed the Lake Hiawatha Firehouse is they had a sign, "Please clean off your fire hydrant." What it should have said is, "Clean off your fire hydrant, it's the law." That would have given a message, a strong message, since this winter I noticed some residents decided they weren't going to do it, and that was not right. Okay, how about you thinking about lowering the fine? If you can't change the ordinance, the fine is $1,200 a day. That's a lot of money. If you can't change the ordinance, lower the fine. But again, there are people who don't want to do it, and not everybody does it like this little old disabled lady. And you know, I really hate to say that about myself, but it's the truth. It's a steep fine. What I didn't mention in my prior visits is the cleaning out of the handicap access at the end of every sidewalk. That's important. You're asking us to clean $1,200 a day fine, and the very ends of the street that have the slope for those in a wheelchair who can't walk too well are being piled up with mountains of snow, and it's being done by our own cleaning department. And by the way, I want to thank the men and women of the department again. This was a terrible winter for them. I appreciate I'm not here about what they did do. I'm here about I'm so tired of what I did do.
Yes. No, I know.
That's important. Please, I don't want to come back every week, every month. But if you need reminding, I'll be here to do it. Because I'm tired of shoveling for 50 years the same hydrant. When I see in town, I don't know if any of you noticed this winter, but there have been residents who were very, very negligent about cleaning out the fire hydrants. You know, I don't want to say they did it and I didn't. But as I thought of something else that you can compensate us shovelers. How about a tax reimbursement for each of the 1,000 private homes that have a hydrant on their property? We get a little reimbursement for cleaning. Not much, but it would be a thank you from the town for the service that we're providing for the other residents who don't seem to appreciate it and help us out. And by the way, I want to thank, the young man isn't here, but there was a young man who came diligently every time there was a snowstorm. And I hope at some point you honor. I'm sorry some of the other people who we did this for aren't here. But if I ever appreciated a human being, it was Nick.
Yep.
And I'm sorry
30
he isn't
seconds,
sitting here tonight, because he not only helped me, and he doesn't even live on my side of town. He came from Lake Hiawatha. There's something else that I thought about. How about, since I heard this gentleman talk about people going to school who aren't even really residents or coming to live with their grandparents, how about for those of us 65 years or older who have lived in town 30 years or more? I'm not going to say the 50 I've been here.
Time's up.
How about us being relieved of our school taxes?
Time's up, ma'am.
Yeah, ma'am, the tax relief issues that you brought up, the council does not have the power by law to enact those. Yeah, well, you should. Right, you'd have to travel down to Trenton for that thought. No, I'm just saying that the council doesn't have the legal power to do anything about your request.
The best time to do it's an election year, isn't it?
Yeah, well, yeah, and the council doesn't have the power to do that.
But please,
Okay.
I'm tired of shoveling. Let's do something. And I even mentioned last time, getting a grant and creating jobs for people to come and shovel the fire hydrant. We create jobs, give some people income, and relieve this tired, disabled old lady. Good night.
Thank you.
Good
Good night. Thank you.
And for the press, there are not mandatory $1,200 a day fines. Those are discretionary, and they have not been imposed. They're there just in case.
No, if someone belligerent.
Good evening, Mr. Inglesino.
Mr. Homiak.
You're right, I do have something to say. We,
Nick, just state your name and address, please.
oh yeah, okay, I forgot. John Inglesino, no. Nick Homiak, Lake Hiawatha. I think the biggest mistake Parsippany made was not conforming to the regional master plan, because it evaluates land use a lot better. Now, from all this rhetoric we heard about this decision, I can't understand how there could be any number, but there can be a need stemming from a local community population in relation to their work, and it can't promote sprawl. So are we going to promote sprawl again? Just because Parsippany has open land, we're going to develop it because it's owned by someone and they want to get rid of it, and now they got an excuse. They're going to have affordable housing. There's 3 issues in Parsippany right now that could have been settled if we were in conformance. Greystone would have been saved. That letter from the council didn't mean anything because you didn't trigger anything. If you were in conformance, you would have triggered something. And I'd have to say, I don't even think we have a historical preservation ordinance at all. Greystone is included in the inventory of historic properties in the Highlands law. So we would, Waterview by now, with all the advocacy that's going for it and that beautiful neighborhood down there and all they know about that landscape, we probably could have got protection for that too. And the Troy Meadows, well, you guys done the right thing with that. But they're suing you. Why? That doesn't make any sense, you see. But we're paying for all of this. It's good for Mr. Inglesino's law firm. But under the Highlands, we would have already had the legal protection. They wouldn't be suing Parsippany, they'd be suing the state of New Jersey. And I don't think they'd want to do that. So when you say what is good for the region may not be good for Parsippany, you can only say that if you don't understand what the Highlands law was all about when it was passed. I'm glad that that land can't be developed. I don't care if I don't live there. And if Parsippany has to be sacrificed for living space for all the humanoids that are coming onto the planet, then so be it, as long as they do it in the right place. Because first and foremost, when we talk about Mount Laurel was a discrimination case. We had a black community that was there since before the Civil War. They're probably even related to slaves that live in New Jersey. And all of a sudden, presto changeo, gentrification, you're out of here. But I don't think the judges really know what they're doing. It doesn't sound like they know what they're doing here. And I have to say that Mr. Christie, our governor, is responsible for this mess that we're in. Because he let the dogs out. He let the developers out. And if we stick to the issue of need, not want, and what lands are valuable to us and our watershed, and yeah, well, here we go. Yep, turn on the faucet. Yeah, someday the water's not going to be there, or it's going to cost more to purify it. Waterview should not be developed for anything under any circumstance. So our biggest mistake is not
Please
being
cut the
a
chatter
member
in the
of
back.
the regional master plan. It's a big mistake because we could have had all these benefits. It's 463 pages. I encourage you all to take a look at it. And it's an advance that's already been made that we can build upon. And standing alone is not the way to go anymore. That's old-fashioned home rule. That's developers' rule. Look what RD's doing to this town now.
30 seconds.
They're not even nice people, and we got to kiss up to them. We should be telling them, hey, get lost. And we'd be able to do it if we were in the regional management plan conformance. That's Parsippany's biggest mistake, and that's the future. Because we could be part of the Highlands, too, and we are. Thank you.
Mr. Homiak,
Thank
opting
you.
into the Highlands will have no impact on the developability of Waterview, and it would have no impact upon Greystone. Legally, I'm just telling you. And as for Mr. Christie, I think he was in grade school when Mount Laurel 1 was decided. That was back in 1975.
All right, anyway.
Good evening, everyone. My name is Nick Ramasa. My wife Melissa lived on Twin Oaks Court by Parsippany High School. Moved in September. I wrote an email a few months ago to the council. Mr. DiPiero was kind enough to respond.
Yeah, you have to, yeah. It's on, but
It's on,
just
just
talking. Yeah.
All right.
There you go.
There we go. How's that? I'm here about a parking issue. It's the first road off Knoll Road, that little dead end there. Every day, Monday through Friday, 9 months a year, anywhere from 12 to 16, 17-year-olds park on my road as an overflow for the high school. And aside from it being inconvenience, being difficult to get out of my driveway, not looking nice, it's more of a safety issue. It started in February when a garbage truck couldn't make its way down the street. And picking up the garbage was the least of my concerns, but my thought was, what if this was an ambulance or a fire truck? it's a big problem for a few parking spaces for kids to go to the high school. And so I raised this issue, and also once spring came around, I talked to a few of my neighbors who had lived there, 2 of them, for 20 years. And when I raised the issue, they almost laughed at me for trying to bring it up. They said apparently this is something they had raised in the past years and years and years. And I think they said they would bring it to the council. They would say, talk to the Board of Ed. The Board of Ed would say, talk to the police. The police would say, talk to the council. And round, decades, here we are again. So I would like to discuss a possible ordinance similar to the one that was enacted on Farron Road behind the high school, where I believe it's September to June, Monday through Friday, 8 a.m. to 1 p.m., a no parking ordinance be enacted. I actually just looked at it on the way over to the meeting. I think it's a great idea and would solve this situation. So I'd like to hear some more thoughts about that.
Just real quick, Nick, that wouldn't solve the situation. What it would do is it would put parking on another road. What I'm gonna do is I'm going to refer to Mr. DePiero, who has been working due diligently on this with the Board of Education. He's contacted my office, and we're trying to move the buses at the high school. And today I spoke with the Parks and Forestry Director, Jimmy Walsh, with regards to that matter. Mr. DePiero has been in contact with the board president and the vice president, and they seem to be interested. So I'm going to let Mr. DePiero take over from here.
Is there any anticipated timetable, Councilman?
At this point in time, we did show some of the school board members the property that we would make available to them up at the Knoll Country Club. There's sufficient parking up there for those buses. It's just so some of the people don't know in the audience, okay? My contention is the 19 school buses you see parked at Parsippany High School, and the 19 spaces reserved for the school bus drivers when they drive there to pick up the buses. That's 38 spaces that they're taking away from the kids at Parsippany High School. These are the juniors that get, seniors can park on school property, juniors cannot. So as the year progresses and more juniors reach license age, and some of them get cars and they start driving to school, they can't park on school property. So they have to look for someplace else to park. And this came up at Ferran Drive 8, 9 years ago, and the residents had the same complaints and the same problems you do, and they're real problems and they're real complaints. I'm not diminishing that. So we did put the no parking down on Ferran Drive. And did we solve the problem? No. We moved the problem. We didn't solve the problem. And if we put the no parking signs that you request on Twin Oaks and the adjacent streets there, we will move the problem again. We will not solve it. The kids will find someplace else to go. And I feel bad for the kids too, because they're getting harassed by residents who have legitimate concerns and don't want the cars parked right across the street from the driveway so they can't back out, or right up to the edge of both sides of the driveway and they can't maneuver, and ambulance services. These are all legitimate complaints. I understand that, and I've been trying to get it resolved. Unfortunately, we had an interim superintendent for 2 years, and we've had school board member changes, and I've had trouble getting someone's attention long enough to look at this. Finally, I was recommending that the school board move the buses to the school board building. That used to be our library. That's sufficient parking. Move the buses over there, but they claim that they have activities and there's no room. So now my search has been to offer the Knoll Country Club parking. This is a lot that's not used by the golfers or by the caterer. It was built when the Knoll burnt down years ago, and we had to rebuild the Knoll Country Club. While it was being rebuilt, no one could go up the top of the hill, so we had this temporary parking lot for the golfers and for and a temporary hut for the pro to use, and now it's pretty much vacant. So I suggested that. The building there, which is a part of the swimming pool, which is very, very old and not very operational anymore, and the building is run down, the school board members said if they could use part of the building for their transportation coordinator, they would be interested. Well, the building is old, so our next step is to try to see if what we have to do, working with the board, to renovate the building so the coordinator could be near her buses. So that's the one thing. That's a longer term. We have to renovate part of the building. As an interim, what was suggested, and I'm talking to the mayor about that now, is there is some parking across the street at the Bowlesby DeGallagher house. It's chained off now so that the apartment dwellers can't park there. But you can't fit you can't fit 31 cars there, which is what you're talking about. By the end of the school year, you have about 31 cars parking on Twin Oaks. You can fit maybe half of that. The Parks and Forestry director is going to measure to see how many spaces could legally be obtained there. And if we passed a no parking ordinance between midnight and 4 a.m. or 5 a.m. or something like that, so that the dwellers couldn't park there overnight, then we could get the kids to use at least 50 of those spaces, take some of those off of your road until we have the longer-term solution. I've been working on this as hard as I can, believe me. I know your dilemma.
And another thing, Nick, what we're looking at doing, I will be meeting with the Traffic Bureau and the chief with regard to one side of the street parking only. I mean, and we'll discuss that. And we should be meeting on that next week, where you can park on one side, but you can't park on the other side. And that would definitely, relieve that area. But our ultimate goal is to get everybody off the street. And one of the reasons why we don't like to put no parking permanently is because if you have company or something like that, so it'll be times, and it is being worked on, believe me, Nick. So,
in case you're interested, Ferran Drive asked for some of the no parking signs to be removed.
Even during the week?
Yes, because the no parking on both sides is a hindrance to them. When they have guests, company, kids come back from college, whatever. So their own no parking signs that they requested are becoming a problem for them too. So they're saying remove them on one side of the street or something.
and you can call the Mayor's Action Center tomorrow, and we'll keep you updated. I'll get your number later. Thank you, Nick.
Before you go anywhere, I think you brought up a very good point with the emergency vehicles. That's a major concern to me, and I know right now we currently have about 2 months left in the school year. So do you think we're going to have some kind of answer from the Board of Ed about prior to the start of next school year? Yes or no with that?
We'll have it by then.
Because, I mean, at the minimum, the one side of the street parking, because if you can't get a fire truck down there, we have a fire or an EMS, that's...
Use the microphone. They can't hear you.
Not to be a scourge, but I had a old minivan in front of the fire hydrant for 12 hours today. Good thing no one needed a fire truck today. I called again, it's not an inconvenience, not to be anti-kids.
No.
We hope we have kids going to the school someday, but
No, but
it's a safety issue.
And I agree with you 100%, because during all the snowstorms, it was horrible over there, and I would go out and see that as myself. But I'll be in touch with you, Nick.
Thank you.
Thank you.
Thank you.
Pat Pataccio, 182 Hawkins Avenue. I'll let John do his apology for me tonight regarding that thing. Just let people that you did acknowledge it. He was he'll be bringing it in next time, the employee information I requested. COA. I think basically all New Jerseyans should be disgusted with our legislatures letting something that was so important just drop. People, wisely, start looking at your legislatures and who we're voting for, because they're not doing anything to help us. In regards to that, finding out we're considered wealthy, we're which we have been for a very long time. I don't know where that's coming from. Our town employees would not agree. Okay?
That's what
Would not agree.
Absolutely. Our town.
The new development that might be planned for Route 10. Let me ask you a question. Would this project be able to be done without us having Jersey City water? Would this project be able to be done with the water that we supply ourselves without the Jersey City water? Jersey City contract will be coming up soon. So, to me, if we're purchasing water just to keep building out, I think we should seriously consider looking into that. The thing right now with the school and the parking, you know, I am so discouraged with our Board of Ed and just
In general.
in general.
Yeah.
Okay? You know, you try to accommodate, but we try to accommodate, okay? In my day, you had a license, you went and you got a permit, to park in the school. That was it. When those permits were done, nobody could park. You were told to get on the buses. Why we are going out of our way to create another place for these buses to go when you're going to have to move stuff is going to cost us some money. How is it going to affect the bus drivers? Because I do know they got to report, people got to check them out, people got to make sure they're working. You know, there's things you got to do. How is that going to be affected? I mean, you know, enough is enough. Let's do what we have. Let's not create new problems, because that's what it's going to be. Somebody's not going to be satisfied. And we really have to start putting down a foot and saying, enough is enough. This is what's here, this is what's going to happen, abide by it or not. Because one thing I know is we don't abide by a lot of things that we have on our ordinances in town, so why abide by anything else? Okay, please think about it carefully. One other thing I have is that resolution number, I just got a question on it, 2015-085. That's the electric energy. That has nothing to do with the Gables, does it? That was mentioned last week. Is Gables Association involved in that?
Oh, you're talking about Gable. I know you're talking about that.
Is that the one they're involved in?
They're just the lead, but the companies that come and go through
I don't even want them as a lead. They led us into that solar project blindly. But that's my opinion. That's my opinion.
Okay. Let's receive the bids, and as we said to Councilman Paluso, that let us look at it, and they don't run it. They just I hear what you're saying, Pat, but right now, let's go through the process and under the light of day too, when we go forward with it, because there's quite a bit of savings that's not to do with solar. Believe me, I'm on the Morris County Improvement Authority and as a volunteer, and disheartened for a lot of other reasons why things happened, the SREC market and the rest
And
of it.
just being very cautious.
Yes,
now,
and I am
watching
too.
what's being done.
Yes, I am too.
Thank you.
And we will be, okay?
Thank you.
That's a commitment. I don't make promises.
Yes, I know
Too
that.
easily broken.
I know that.
Commitment.
You're a commitment person.
Yes, I am. I'm committed. I got it. A long time ago, Pat, I got it. Thank you.
Loretta Grignani, 11 Road Terrace, Parsippany. Last week, a resident made a comment. I respect this resident. He comes before you often with his concerns and his suggestions. As he did tonight, one of his comments was in regard to group homes. His comment also was, not in our neighborhood. Why not in our neighborhood? Why not? Why not in our backyard? The group homes and the clients that are in these group homes, for whatever reason, perhaps parents are aging and they are no longer able to care for them, or they have disabilities that are so severe, physically or mentally, that they must be placed in a facility. To the parents and the families of these residents, the families know that they will be taken care of. They will be supervised on a 24-hour basis. They will be provided a home for the rest of their lives. I think what we should be concerned about is not only the taxes that aren't paid, because they are a tax-exempt entity, but are the homes cared for? Are the lawns mowed? Are there disturbances within the homes that the police have to be called? These are the concerns that I have. Also, I know you've seen many residents. They work in ShopRite. They also work at the PAL building during the lunchtime. Rose House provides lunch, and their clients will serve you. Perhaps you will go to there, and you'll be received with a smile. If you go often enough, as our mayor does, you may also get a hug. These are clients that I believe have self-worth, feel good about themselves. They are providing something to our community. I know you know the gentleman that walks North Beverwick Road. He has been doing that for many, many years. His family didn't have the heartbreak of placing him in a facility when his parents passed away. He walks up and down North Beverwick Road. That's his job, protecting the stores on North Beverwick Road. He's been doing it for many, many years. His parents, after they died, a sister who lived out of town moved to Lake Hiawatha and is living with Howie today. My family also had to make a decision many, many years ago to place my brother in a institution. I'm sure you all have heard of Willowbrook in Staten Island. That was an institution because they didn't have group homes. My brother has lived with my husband Adam and I for close to 30 years. He is a 69-year-old child. When he was well and able, he went to a facility in Fairfield that was run by ARC. He had menial jobs that they did. He would come home with gifts for my parents or for me during the holidays. They would also have contract work. Contract work was perhaps putting a toothbrush and a toothpaste in a bag that was given to a hospital. And he would come home after a 2-week period and say to me, "Sissy, how much have I made?" "Louis, you made 25 cents for 2 weeks," because that's what his capabilities were. 25 cents in 2 weeks. But the look of satisfaction, the look of accomplishment, the look that he did something, did a job, was worth more than the 25 cents. It was worth $1 million. He doesn't know what the value of $1 is or 25 cents, but the look on his face was all that we were concerned about. I know there are issues with taxes. I also heard tonight our COA responsibilities, which can be great.
30
possibly.
seconds.
I ask this council and future councils to say yes each and every time a group home comes before you and asks for a tax-exempt status. Say yes, because my community, your community, is an all-inclusive community. We are not an exclusive community. Thank you.
I will say this, Loretta, and I encourage every council member to go to the PAL for lunch from 12 to 1 o'clock. It's really an enlightenment in your heart, and with these individuals that touched me in a way. In fact, before we had any group homes in town, I went to Hanover Township to one of the group homes, knowing that Parsippany might be getting group homes. And I have to tell you, once again, those individuals were just so happy that they could, and they get trained to live on their own, to help themselves out. And it's very important. And like Loretta said, when they serve you at the PAL, it's not about the money for them. It's the fact that they accomplish something. So I encourage every council member to go to lunch at the PAL, and you will enjoy the experience.
By the way, we've never had any complaints from any neighbors of the group homes. I was on the board of directors for our first ARC group home in Lake Hiawatha for 15 years. And never, when they first moved in, there were a lot of concerns. In fact, that first meeting, this room was standing room only, with rumors and misinformation that was spread. And as more and more of the people learned what it really was, that crowd dispersed, and there was just a few hard noses at the end that still didn't want them. But never have I heard a complaint about any of the residents in any of the group homes that we have in Parsippany.
And I'm glad you told me the names of the gentleman Hiawatha. I've been calling him Joe all these years. I call him the mayor of Lake Hiawatha because he goes up and down the roads, and he always comes up to me when I'm at Quick Check. Says, Mayor, you know what we got to do? I said, okay, we're going to do it, Mayor. So it's really nice that, and he's been there a very, very long time. And if you want to get a history lesson, he'll give you one.
I'd just like to add, Loretta, it's important to have an equal balance with things. And, I spent several hours this morning. I'm on an advisory board for Employment Horizons for people with disabilities. And, one of our topics of discussion today was ensuring that, people with disabilities that have autism, that grow up, they can actually work and contribute to the community. And there's a legislation right now that's going into play which could eliminate places like ARC, places like Employment Horizons that support people with disabilities. We want to ensure that they have equal pay, but we also want to work with our legislation to ensure New Jersey does the right thing for disabled people and, our children that are growing up with disabilities as well. But thank you for sharing the story. Appreciate it.
Okay, see no one else come forward, entertain a motion to close the public hearing.
Motion.
Motion made by Mr. Valori, seconded by Mr. Stanton. Roll call.
Mr. DePiero.
Yes.
Excuse me, Mr. Paluso.
Yes.
Mr. Stanton.
Yes.
Mr. Valori.
Yes.
Mr. Karifi.
Yes.
Before the consent agenda is read, I have a couple of questions that came up only because of Mr. Inglesino. You had mentioned something about closed session with a question from last week. I see Resolution 2015-83 and Resolution 2015-87. I support obviously the wellness program. I also support the benefits of our employees that work so hard for us. But my question to you is, there's verbiage in here that says the health insurance broker requested, but our health insurance broker was not approved. Could you help clarify that for me before we vote on this?
Again, Mr. Paluso, I suggested that we discuss the issue in closed session. If you want to table them and then vote on them after closed session, that's certainly an option.
Could we vote on them after closed session, and once we have that
You'd have
answer?
to make a motion to table those resolutions and reconsider them, pardon me, after the closed session. That would be an option that you would have.
Okay. Then I'd like to make a motion to table them to be voted upon after closed session, just so that we have information.
Well, just read off the
And
numbers.
it's Resolution 2015-083 and Resolution 2015-087. Do I have a second?
Second the motion.
Motion made by Mr. Paluso, seconded by Mr. Valori. Roll call.
Mr. DePiero.
Yes.
Mr. Paluso.
Yes.
Mr. Stanton.
Yes.
Mr. Valori.
Yes.
Mr. Karifi.
Yes.
I also have an additional question on two resolutions, one in which last week I asked for this resolution to be put together, which was Resolution R 2015-089. I have some questions. I understand that the legal effect of the resolution is not intended to consider what would be developed on the property, but the plan comes later in the next phase if we send this to the planning board. And what I'm referencing is the Staby project that was presented to us.
I'm sorry, which resolution are you looking at?
89.
Resolution 2015-089,
89.
redevelopment property.
Authorizing the planning board to conduct a preliminary investigation on certain properties.
That's
Yes. What- okay,
Denver.
what's your question?
Okay, so my questions is that, I had suggested to put the resolution together, but after careful consideration, I realized that there are certain costs associated with it, such as the planning and the legal fees. I do not want those fees incurred by the residents or taxpayers of Parsippany. Can you tell me if a bond has been put in place to reimburse us for those fees upon approval?
No, Mr. Paluso, that's not the way the law works. First of all, in a redevelopment project, all of the fees associated with the redevelopment effort are, in the first instance, incurred by the municipality. Once you adopt a redevelopment plan, and only after you adopt the redevelopment plan, can you then recoup those fees from the designated redeveloper. Under the that's the way the redevelopment law works. And
So we will recoup the fees then for engineering and legal?
Yes, you recoup all of your professional fees once the redeveloper is designated. The way the redevelopment law works is you don't have powers to contract or charge fees until after you've adopted a redevelopment plan. The redevelopment plan doesn't come until after. First you have to blight the area, then you adopt the redevelopment plan. There's a case, it's a Tarragon case out of Hoboken, about 2005, in which this issue was litigated, and the court came down very clearly in saying that you recoup fees after the redeveloper is designated. And in our redevelopment agreement, it's like, paragraph 1 says that, as a condition of being designated, you will pay X dollars, and you just take the planning and the legal bills incurred, and the redeveloper has to pay those fees right off the bat. So you do recoup the fees. It's just the way the law is set up, you have to front the money and then you recoup them.
Do you know how much we'll be fronting on this project, approximately?
I don't. I mean, from our perspective, the legal is really minimal. We prepare the resolution. I spent a little time at the planning board meeting. We would review the plan. Depending upon the complexities of the redevelopment agreement is really where, most of the funds are. I mean, and that will vary. In this particular instance, I don't really know what's contemplated by way of a plan yet or what the complexities are there. I know that, you're talking about property that's bordering another municipality, which may add a complexity. I'm not really sure. But once you get to that point, you're pretty much assured you're going to recoup the monies as soon as the redeveloper is designated. And the redeveloper will have to pay the money immediately. That'll be a condition in the agreement.
Okay, so we would recoup that, but how much out of pocket are we looking at? Because the budget process coming up as well. Are we looking at $500,000 in fees?
No, you're not looking at $500,000 in fees. It's not enough that's material to change what the historical spending on the legal budget has been. So if you look at it in the context of what your legal fees historically have been, it's not going to impact your legal budget. What will impact your legal budget is the COA issues.
Now, are we obligated, once we approve this evening, if we do approve it, that we have to move forward with the project after the planning board does come back with a decision and they do say it is in need?
No, the planning board makes a recommendation, right? So they engage the planner does a study, they have the public hearing at the planning board, and then the planning board makes a recommendation. Only the council can actually declare the area to be in need of redevelopment. The planning board could make a recommendation, and you could never act upon it if you didn't want to.
I see.
Or they could make a recommendation, and you could reject the planning board recommendation, or you could accept the planning board recommendation. So you have complete control of the process. Even after the declaration is made, you may decide you don't want to go forward with the redevelopment plan. Project dies. You may decide you want to go forward with the plan. Project goes forward. So you maintain control of the pace and what's done the whole way through.
So it doesn't obligate us to have an overlay zone either?
Doesn't obligate you to do anything at all. It's your discretion as to whether or not you want to take the next step in the process.
Because I do have complete confidence in, our zoning officials that we put on these committees. It's really their job in zoning usually to review these applications.
Well, it's not an application. The redevelopment is not zoning. Redevelopment will be a redevelopment plan, and your professionals, your planner really is the person who is taking the lead, because they're the ones that are authoring the plan. They're the ones who are also conferring with whether it be a contract purchaser or others interested in the marketplace to ensure that you're actually preparing a redevelopment plan that the market is going to react to and want to implement. One of the problems that municipalities incur in going forward with redevelopment and acting plans is that they have a planner come up with a plan that the marketplace doesn't react to and you can't get it going. So having that collaborative, interactive process between your planner and either the property owner or contract purchaser or prospective redeveloper is really important. In this particular instance, you appear to have those ingredients in place, which really is the right kind of dynamic. But you're not obligated, to continue. You can stop at any time you want, or you can reject the recommendation of the planning board.
So
maintain
although you
control.
start the process in step 1, you don't have to continue the process in step 2?
Correct. Just by starting the process, you can stop it at any time.
And can we have more control under this type of plan rather than it going through zoning? Am I correct?
Yes, you are. The redevelopment plan, one of the benefits of a redevelopment plan is it provides municipalities with an enhanced control over what's developed, because in a redevelopment plan, you can get much more specific in terms of what your requirements are than you can with the zoning ordinance.
Would it be legal in the sense that we ask them to fulfill some of the low-income housing requirements that we're confronted with right now?
Again, that's an excellent question. Again, one of the policy matters that I think you should consider is adopting an ordinance, and I think you heard Mr. Snikes echo this tonight, is adopting an ordinance that would require a certain percentage to set aside of low and moderate income housing with respect to any multifamily project, whether it be...
This is the Dialogic property we're talking about, right?
Yeah.
Yes.
Through a zone or through a
Okay.
redevelopment plan, so that you can be assured
Robert's
of...
question is moot, because they plan on putting a shopping center along Route 10 rather, which is in Parsippany, and they're putting the rental apartment units in Hanover.
Well, I think that's a little, I think that's,
That's
I think that's,
That's up
I think,
for
with all due respect, I think you're a little bit ahead of yourself
Yeah.
there.
Am I?
Yes.
Yeah, so I think that, but the councilman's question is a good one in the sense that whether it be this particular project, I think, or any project, I understand the question to be of general applicability, spurred on by what's before you, is that, it is something you probably want to consider, depending upon what Mr. Snikes tells you, in his view, your number is or could be, and as coming up with a plan in order to satisfy that number, you may want to include mandatory set-asides in your multifamily zones or in your redevelopment plan areas in which there is a residential component. Obviously, you don't want to do that
Yes.
for plans that are only commercial, because...
Yeah, on the surface, it appears to be a smart plan, and it seems to be a great economic development tool as well. But as long as the process is fair and responsible and transparent to everybody is my concern.
Well, you control that.
Okay. Now, the ordinance that you're suggesting to pass in order to have every project have a set-aside for COA obligations or low-income housing, would that have to be prepared and approved prior to this project? Or because we don't have it approved yet, they're not obligated to
No, you would, you don't, there's no need to run out, next month and initiate an ordinance. I think that the suggestion I've made is one that I make to you as policymakers to consider. I think obviously there are benefits to that, but I think you have to get input from your planner first.
Right.
In terms of what he feels your obligation is, because once you understand what the number is, then you got to come up with a plan to say, how are we going to get there? So if you proactively look at the town in terms of zones and in terms of prospective redevelopment areas, and you plan, set aside. So let's say you spot an area in town which you suspect may be in need of redevelopment, and you're contemplating a redevelopment plan there, maybe you want to go through that process, and you can come up with density calculations and have an ordinance that would require X number of those units to be low and moderate income housing. You go to a court and you say, hey, we're planning for what we believe our obligation is. That's the kind of dynamic, that's the kind of thing that I think will be really, really helpful to Parsippany, not only in terms of planning its future, but also in controlling where affordable housing is going to be placed. And that's the thing that I want to stress. The more proactive you are in the planning process, the more control you will have.
Who is we in the planning process? Is it the council or the planning board?
Well, ultimately, it's the governing body. But you want that to be done in conjunction with your planner and presumably the planning board as well. But, it's really the municipality taking a proactive approach.
And we could obligate them to take a proactive approach with a set-aside without having the ordinance in place, is what I understand.
Well, the other tool that I've used in municipalities is that, we've just, as a condition in the redevelopment agreement, required a set-aside of affordable housing. Now, where that sometimes breaks down and you get into the economics of development, you've got a land price, right? And if affordable housing becomes an afterthought, you've arguably hurt the economics of the deal because, what's the land price based on? It's based upon density, FAR, what you can put there. The affordable housing units typically don't have any value in terms of the economics of a deal. They're usually, just part of it as something that's required. So to the extent that you have an ordinance, then, you're signaling to the marketplace, you got to factor that cost into your deal. Correct. And it makes economic development, more predictable. And from your days as a banker that the more predictability you can build into an economic model for a project, the better the chance is that those projects are going to get done.
We have to find equal balance because each apartment we're losing value by going to low-income housing, but we're meeting our COA obligation at the same time.
Right, but adding predictability to the market is a good thing generally, which is why, at some point, another reason why at some point you may want to consider an ordinance. And I don't think that point is too far in the distant future. I just think it needs to be done in collaboration with your planner as part of the bigger picture of trying to gauge what your obligation is going to be and how you're going to attain that obligation. And what I'm suggesting is that an ordinance, a mandatory set-aside ordinance, may be something that you want to consider at that point in time.
So prior to us voting on this evening, do we have to ensure that a redevelopment agreement is put in place?
No, that comes after. Redevelopment is you got to think of redevelopment as a building process.
Right.
And it's step by step. So first step is the blight determination. Second step is redevelopment plan. Remember, you have no ability under the law to enter into contracts or do anything until the redevelopment plan is adopted. That's by ordinance.
Because we're asking them to complete a study on the planning board right now, but then afterwards, we have to vote upon accepting their recommendation, and then we're going to have a public hearing as well, correct? And public notice?
No. The way the step one is resolution to the planning board to conduct a study. Step two is the planning board engages the planner to conduct the study.
Right.
Step three is there's a public hearing at the planning board. Public hearing does not occur here. Public hearing occurs
So
at the
public
planning
hearing
board
is
at the planning board level. Step four is of the first part of the redevelopment process is you vote on whether to accept the recommendation of the planning board. That is not a public hearing.
Okay.
And it's important that it not be a public hearing because by law, the public hearing on a blight study is at the planning board level. You're just taking an up or down vote.
Sure.
So you don't open it up to the public for comment. That's done at the planning board level.
Right.
Okay, and then after that, then you go through the redevelopment plan process, which is an ordinance, akin to a zoning ordinance by way of procedure.
I'm familiar with it, but I want to make sure that the public understands the process as well, because this is something that's not done on a regular basis. Also, the final question I have is our neighboring communities that we work with is important, to have a good relationship with them. Have we spoken to Hanover about this project already, or has the developer spoken to them yet?
I've had a meeting with the mayor from Hanover Township.
Ron Francioli?
Yeah, I had a meeting with him, and you know, we're still in discussion with them.
It was a very
And-
good meeting.
Huh?
It was a very good
It was a
meeting.
very good meeting, and then we'll see how it goes from that point on. You know, we just don't, I mean, to continue to have meetings with them, it was really, it might be moot if we don't have the planning board render a decision on what, you know,
Right.
on the redevelopment, and then taking 300,000 square feet off the vacancy.
First step is the blight study.
Yeah.
Yeah. Okay, thank you, John. I do have another question on the consent agenda for Resolution 2015-090 for the place-to-place transfer liquor license for ShopRite. I understand ShopRite is here today. Hello. The question I had, based upon the limited information that I've seen in my packet, when we approved that place-to-place transfer for you, you're taking on additional square footage of your store. I believe it's 1,286 square feet, so it's nice to see that you're expanding on that facility. Will you be moving the alcohol out of the aisles away from the youth of our community and also people with various religions that don't want to see alcohol while they're shopping?
Well, hold on a minute, by way of procedure, what, is this, is there a hearing for the?
It was advertised for a hearing if they
So the
so
hearing
wish.
is tonight.
If they so wish, yeah.
All right, so if we're gonna have a hearing tonight, then I think,
Take like a 5-minute break.
yeah, the procedure would be that, that you would have a hearing, so I think we should have a witness, you should probably be sworn and identified, and then have the opportunity for council people to ask you questions.
Okay, so should this be tabled for that question and voted on later?
Yeah, if you're gonna open it up.
I can answer the question. I don't have to have the public do it. They've acquired the additional 1,200 square feet. That was an ice cream store, something that was next door. Its sole purpose is to store cases of liquor. It's not going to be used for additional selling places. As I understand it, some of the stock that's on the shelves can now be stored properly in this spare space. Since we approved the liquor license transfer, that exists now is the entire building. If they expand the building, then the liquor license has to include the new expansion. But it's strictly for storage, it's not for additional retail space.
Well, and we went through, and I can't remember, Councilman, whether this was before you were on the council or after you were on the council, but the council went through a pretty elaborate, very elaborate hearing process on the issue of the liquor license transfer for this store, and addressed all of the questions that you just raised and more. And, you know, there was extensive testimony and dialogue, you know, concerning those issues. And I guess, you know, sort of the best evidence of whether or not it's working is the fact that I don't think we've had any complaints or any issues of
All the
concern.
projected fears didn't happen.
Yeah,
No one's
didn't-
drinking in the
none-
aisles.
Yeah, none of that arose.
Well,
that I'm aware of.
Well, these are what we're being told was going to happen.
no, I will say this. I exclusively shop at ShopRite, and although I don't drink, if you don't believe that, I don't. But my wife does, and I buy wine. I got to tell you, they're very strict with the cashiers. They're very strict with the process. It's I've got to say, I was in the very beginning, I was very much against it, but I as I go there more and I see, you know, they have security all over the place. I've been there and they shut down at 10 o'clock. You know, they abide by all the rules and regulations of the law. So, you know, and I'm kind of proud that I got to show my driver's license when I. So.
It's nice being carded when you're a certain age, right?
Well, even the cashiers, if there's a cashier is underage.
Yeah, you can't go to the cashier.
Well, you can go there,
But won't
but
go.
but they can't ring up liquor. It blocks them because the computer knows that that's an underage cashier.
One
So
of the
they
things-
have to call an adult an adult over to ring up.
As I recall, there were a lot of security protocols that were put into the existing license as conditions. My suggestion is that you incorporate those into this as well.
No, those are, you don't have to. The liquor license covers all of that now, where it is. All they're doing is adding 1,200 square feet to store boxes of liquor.
Okay.
Okay? But their whole facility has to have the liquor license.
Has to have the liquor license.
That's all they're doing.
And honestly, if they weren't storing and they were gonna, it really shouldn't matter anyway towards that.
If nothing else, they're gonna clear some of the shelves of inventory that they don't need now because they can store it in this 1,200 square
The point I'm
feet.
making is that the conditions that are already in place would apply.
Will remain in place.
Yeah, that's all, that's all I'm,
I can tell you, when that issue came up a few years back, I went to the store, I met with the owner. He ran me through the whole procedure and everything. I mean, they have a lot of procedures in place, and I was very satisfied at the time, and I supported the ordinance and the application at that time. The security measures that they have in place, and like it's been said, we haven't had any problems.
Yeah, the reason why I raised the question, and, you know, ShopRite's a good community neighbor, I'm not discounting that, and I do shop there as well as other local stores in the community. But the question was that there's been some concerns by residents that have been voiced to me about, you know, liquor being in aisles and their children seeing it, because we want to protect our youth from alcoholism, which has always been on the rise. I'm on the Municipal Alliance Committee for many years prior to being a councilman, and we've always talked about those concerns. So, you know, I hope ShopRite just understands that, you know, I have concerns for the youth of our community. And also, we had some comments from religious people that are shopping and they don't want to see alcohol because they don't drink. It's part of their religion, they don't drink. So they didn't want to see it next to their food that they were purchasing. So what I was wondering when I saw the additional square footage is I was hoping that that would be added to the additional extension for the liquor store area, and that would be a separate liquor store with egress from the street, and it would not be part of the store. You could still enter the store, but I was really hoping that that would be the case. It would be separate like you used to have in Arlington Plaza.
And ShopRite, just so you know, Councilman Puso, they also participated in some of the Municipal Alliance Committee's projects. With, you know, don't serve on the minors. We did photo shoots with ShopRite. Ned Gladstein has been a great partner.
They also provide food for our concerts and things like that. So, you know, I'm not discounting ShopRite, but, you know, I do have an obligation to protect the youth of our community and to address the concerns of residents. So that was my questions. Thank you. Move forward, Council.
Go ahead, Brian.
Consent agenda. Be it resolved, all items listed with an asterisk are considered to be routine, non-controversial by the Township Council, be approved by one motion. There'll be no separate discussions on these items unless a council member so requests, in which case the item be removed from the consent agenda, considered in its normal sequence on the agenda.
Second.
Motion made by Mr. Stanton, seconded by Mr. DePiero. Roll call.
Mr. DePiero?
Yes.
Mr. Paluso?
Yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes. Ordinance 2015:07.
An ordinance of the Township of Parsippany-Troy Hills, County of Morris, State of New Jersey, authorizing the acquisition of land known as 805 South Beverick Road and also known as Westbrook Farms, Block 764, Lot 31, pursuant to the local land and buildings law. Be it resolved that the above ordinance be introduced, read by title, and passed on first reading at a meeting of the Township Council of the Township of Parsippany-Troy Hills held on April 21st, 2015, and that said ordinance be further considered for second reading and final passage at a meeting to be held on May 19th, 2015 at 7:30 p.m. prevailing time, or as soon thereafter as the matter may be reached at the municipal building in said township, at which time all persons interested shall be given an opportunity to be heard concerning said ordinance. Be it further resolved that the clerk be authorized and directed to advertise said ordinance with the notice of introduction thereof being published in the official newspaper according to law.
Second.
Motion made by Mr. DePiero, seconded by Mr. Stanton. Roll call.
Mr. DePiero?
Yes.
Mr. Paluso?
I'm honored to say yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes. Okay, at this time, we'll be going into closed session. Resolution, whereas the Open Publics Meeting Act, Public Law 1975, Chapter 231, permits the exclusion of the public from a meeting in certain circumstances, and whereas the Township Council is of the opinion that such circumstances presently exist, and whereas the Township Council wishes to discuss attorney-client privilege, and whereas minutes will be kept, and once the matter involving the confidentiality of the above no longer requires confidentiality, The minutes can be made public. Now therefore be it resolved by the Township Council of the Township of Parsippany-Troy Hills that the public be excluded from this meeting.
And the record should reflect, we're going to discuss RD Realty, which is a pending case, and we're also going to discuss legal advice with respect to issues raised by Councilman Karifi tonight concerning the status of the health broker of record, and also legal advice on issues relative to open space contracts and funding.
I'll second.
Okay, motion made by myself, seconded by Mr. Stanton. Roll call.
Mr. DePiero?
Yes.
Mr. Paluso?
Yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes.
We're on.
Make a motion to reconvene into open session?
Second.
Motion made by Mr. Stanton, seconded by Mr. Paluso. Roll call.
Mr. DePiero?
Here.
Mr. Paluso?
Present.
I'm sorry, we're voting to reconvene.
Yes.
It's not a
Yes.
roll call. It's not a.
Oh, yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes.
I don't know, have him,
Okay, I'd like to make a motion to vote on Resolution 2015-083 and Resolution 2015-087.
Together. They can do them together?
I'll second.
Motion made by Mr. Paluso, seconded by Mr. Stanton. Roll call.
Mr. DePiero?
Yes.
Mr. Paluso?
Before I vote, I just want to say that, I am always concerned about the welfare of our employees, and the wellness coaching service is very important for our employees, and also our prescription insurance benefits as well. I appreciate the attorney answering our questions on the resolution, and I vote yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes. Okay, at this time, I entertain a motion to adjourn the meeting.
Make a motion.
Motion made by Mr. Valori, seconded by Mr. Paluso. Roll call.
Mr. DePiero?
Yes.
Mr. Paluso?
Yes.
Mr. Stanton?
Yes.
Mr. Valori?
Yes.
Mr. Karifi?
Yes. Good night.
Brian, good luck.